Now the parliament takes over. The parliament takes over to decide how should a person be provided with the citizenship of India, how can a person be rejected with the citizenship of India. All those kind of things will be dealt post 1950 by Indian Citizenship Act of 1955. So according to the change in the social situations, in fact, number of times the Citizenship Act of 1955 has got amended. So in 1955, it has got into effect. 57, 85, 86, 92, 93, 2003, 2005, 15 and 19. So you have in fact 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 times have amended the Indian Citizenship Act of 1955. Fine. 9 times you have officially amended the Citizenship Act of 1955. Now please understand, the Citizenship Act of 1955 can be amended by a simple majority. Okay. The provisions in relation to the citizenship can be amended by the parliament through a simple majority. Fine. Just like an ordinary legal process. Why? Because this is a law, this is an act, it is not the constitution. So it can be amended by a simple majority. And always keep in mind that regarding the citizenship, the final authority to decide is always the government of India. Fine, the government of India. And who will deal with the citizenship? Which ministry? Yes, it is the Ministry of Home Affairs. Do not get confused with the Ministry of Foreign Affairs. It is the Ministry of Home Affairs. Ministry of Home Affairs. So the ultimate decision regarding the citizenship is Government of India, or you may say that there's the Ministry of Home Affairs. Fine. Now, we are going to deal with the Citizenship Act of 1955. We will try to understand what does the Citizenship Act of 1955 says. The first matter that is under our discussion is, under the Citizenship Act of 1955, how can a person acquire, or how can a person be provided with the citizenship of India? There are different ways by which a person can be the citizen of India. Say, for example, there is by birth, isn't it? By registration, by naturalization, by incorporation of territory. There are a lot of ways. So we will see each and every one. So these things are in fact mentioned in which act? The Citizenship Act of 1955. So majority of the aspirants think that these are mentioned in the Constitution of India. Not in the Constitution. These are governed today by the Citizenship Act of 1955. Very limited provisions the Constitution speak about the citizenship. It is extended by the Parliament of India through this particular act. Okay, fine. Yes, by birth, how can a person be the citizen of India by means of birth? Okay, how can a person be the citizen of India by birth? The concept is known as jus soli. Jus soli means by virtue of soil, which means on the basis of the soil in which you are born. Fine. On that basis, India recognizes citizens. As you have already told you, isn't it? You have already told me that it is on the basis of birth that you will be recognized as a citizen of India, isn't it? We will see what are the conditions. Suppose if you are born in India, fine, you are born in India. Okay, you are born in India after Jan 26, which is very clear. That is, we are speaking about post-Republic period. Okay, after Jan 26th of 1950, before July 1st of 1987, you does not wanted to remember this name. The reason because is that, why is this date provided here? It is because from 1950 to 1987, July 1st, we were following one condition. After that, there was an amendment. We will follow another condition. That means, you see this, there was an amendment in 86. So, until 87, we were following on the basis of birth, automatically a person will be recognized as a citizen of India. From 87, you will follow that either of your parent needs to be citizen of India. And even that, even after 87 to December 3rd of 2004, we will again change the condition, which means there were in fact amendment in 2003, in 86. So this is the reason why the cutoff date is provided. So what you need to know is only the present status. That is the latest version, which is this. Okay. These are all amendments. Fine. So I will explain to you all these three things. But the things which you need to remember is only the latest one. That means those who are born in India after December 3rd of 2004. That is the present time. Isn't it? Present time. This is on or after July 1st of 1987. But we have here December 3rd, 2004. So this date is already over now. This is the present condition. Fine, this is the present condition. But we will see exactly what is the condition even before that. Okay? Yes. So see this. By means of birth, a person be recognized as citizen of India. How? If a person is born in India, okay, if a person is born in India, now which India we are speaking about? Now, the present India. It is not the undivided India. Why? Because we are speaking about a person born after Jan 26th of 1950, but before July 1st of 1987. Okay. So originally this particular law, okay, just listen here. Originally this particular law was speaking, that is on Jan 26th of 1950, or during the commencement of this law, which is the Citizenship Act. Originally what was written was that person born after 1950 Jan 26. That's it. In 1987 they have written a person born in Jan 26th of 1950 and before July 1st of 1987. Which means there was an amendment inside the law. Inside the act, there was an amendment. Clear? Is it clear? Okay, fine. So, a person born in India after 1950 Jan 26 and before July 1st of 1987, irrespective of your parents' citizenship, if you are born in India, you will be automatically recognized as the citizen of India. We are speaking about those individuals born within this time frame. Okay, within this time frame. It is not what is governing now. It is within this time frame. That is 1950 Jan 26 to July 1st of 1987. In between that, if a person was born in India, regardless of the citizenship of their parents, that person, by virtue of soil in which that person is born, that person will be automatically recognized as citizen of India. Now the condition changes. That means in 1986, there was a constitutional amendment. So there was a change in the condition. Now we say that if a person is born in India, the condition is that you need to be born in India. Fine. It is the first condition is that the citizenship will be on the basis of birth. So the condition stands still. If the person is born in India on or after July 1st of 1987, because in 1986 there was an amendment. So this amendment has come into effect on 1987. So from this particular date, the condition changes. Now we say that if you are born in India and either of your parents are citizen of India, you will be automatically citizen of India. So initially we have said that initially there was a relaxation in the provision, isn't it? Initially, the parent citizenship was not an issue at all. The only condition was that you need to be born in India. Now, after 1987, the condition changes. It is not only that you born in India, but your parents, either of your parents also needs to be citizen of India. So you born in India and your parents, one of your parents born in or one of your parents is citizen of India. In that case, again, you will be recognized citizen of India. Now the condition again changes. In 2003, there was again a constitutional amendment, sorry, this particular law amendment. And this amendment says that a person can be the citizen of India if that person is born in India. Now the condition is getting more stricter. And what is the condition now? Sir, both of your parents needs to be citizen of India. Initially, we said parent citizenship is not an issue. Then we said one of the parent needs to be citizen of India. The third condition says that, sir, it is not a matter that it is the deal is that both of your parents needs to be citizen of India. You should be born in India as well as you should be born for the parents who are citizens of India. So this is what is governing you. Your father, mother, they are citizens of India. And you are born in India. That is the reason why you are citizen of India. Is it only because of the reason that you are born in India? No, it is also because of the reason that both of your parents are holding Indian passport. They are Indian citizens. That is the reason why you are citizens of India. You are citizens of India by birth. Why? Because you are born in India as well as your parents are citizens of India. Or you are born in India, one parent is citizen, another one is not, an illegal migrant. Okay, so you are a citizen of India or this condition. Fine, you are recognized as the citizen of India, maybe because of this condition or because of this condition. So this is what is governing now by birth. Okay, by birth, even your child will be recognized as citizen if you as well as your partner are citizen of India and your child is born in the soil of India. That child will be recognized as citizen of India. Now, if your partner is not an Indian, your husband or your partner is, or your wife or your partner is not an Indian, suppose, if that person is an illegal migrant and you have given birth to a child in the soil of India, sorry sir, that child will not be recognized as citizen by birth. And who is an illegal migrant? I'll give you an example. Say for example, suppose a person have came to India for the purpose of any kind of hospital emergencies. Say for example, a person from Pakistan or a person from China or a person from Somalia came to India for the medical purpose. Fine. That person came in India and fortunately or unfortunately, you have fallen in love with that person. After your marriage, you have given birth to a child. That person has initially got a permission to stay in India for 6 months. But that person, due to the love affair, is staying in India after 6 months. That is without permission. And you have given birth to a child. In that case, your child will not be recognized as citizen of India by birth. The reason being is that your partner is an illegal migrant, isn't it? He has got the permission to stay in India only for 6 months. He has exceeding the limit, or he has exceeded the limit. Now he is staying in India for more than 6 months. That means your partner is an illegal migrant. Your partner should not be an illegal migrant. So if your partner is not an illegal migrant and your son or daughter is born in the territory of India, that particular child will be recognized as citizen of India. Otherwise, there is no scope for recognizing that children or that child as the citizen of India. Clear? Understand? Fine. So what is governing now is that a child born in India after December 3rd of 2004, the condition is that both parents needs to be citizens of India, or otherwise one needs to be a citizen of India and the other partner needs to be, or other parent needs to be not an illegal migrant. Fine. So this is how a person by birth can recognize or can be recognized as the citizen of India. Clear? Fine. By means of birth. Now, sir, if not by birth, which means I was not born in India, then how can I be the citizen of India? I was not born in India, which means I does not have the relation with the soil. Then there is a scope that just sanguinis, that is by virtue of blood, by virtue of blood. In other words, on the basis of your parents or grandparents, etc. Fine? Or preferably parents. We will see in detail. Suppose this is India. Fine? You are born outside India. Say, for example, you are born in United States of America. Okay? The cutoff date is 26th Jan 1950 to 10th December 1992. So you will see a constitutional amendment word. You will see a constitutional amendment in the year 1992. It is not the constitutional amendment, it is the amendment on the Citizenship Act, which means from 26th Jan 1950 to 10th December 1992, you will follow one condition. Okay, you would have been following one condition. Post 1992, you will be following another condition. That means there will be another constitutional amendment. 2004, that is post 2004, there will be another amendment that there will be change in condition again. So what is governing now is after 2004. But we will try to understand even what happens before, or we will try to understand what are the proposed changes. Fine. So person was born outside India. Person born outside India. In between 26th Jan 1950, 10th December 1992. Fine. So this is the cutoff date. There is a compulsory provision that if that person needs to be recognized as the citizen of India by descent, his father, it's not parent. What was initially saying was that the father needs to be citizen of India at the time of birth. Sir, it is politically incorrect. Is it politically correct? Father needs to be citizen of India. Why not mother? Gender discrimination, this is, isn't it? So this was the condition then. But later it will get changed. You will see that. So earlier there was a perspective that it is the father who will go out of the territory of India and will hard work for the betterment of the welfare of family. There will be change in the perspective, and that change in the perspective will be reflected in the amendment. So that is what I have told you. The social changes will be reflected in the amendment of Citizenship Act of 1955. So initially the Citizenship Act said that by descent, that is by blood, by virtue of blood, if a person who was not born in India needs to be recognized as the citizen of India, the compulsory provision is that his or her father needs to be citizen of India at the time of the birth of this individual, which means his father should be citizen of India at the time of this baby's birth outside India. Okay, by descent means he was not born in India, he was born in somewhere else, say for example US, but at the time of birth his parent was having Indian citizenship. Fine, then you will be recognized as the citizen of India by descent on the basis of your blood relation. Are you getting this? Blood relation. Fine. Now the situation changes. Now the situation changes in the sense that the father will be changed to either of parents. Now it is politically correct, isn't it? So we have almost took 42 years to correct this mistake, or 40 plus years, or you may say 35 plus years to correct this mistake, because the law has got commenced in 1955. So it is almost 37 years we have got to correct this mistake. The political incorrectness in the Citizenship Act has got corrected only after 37 years. Fine. So if a person born outside India after 10th December of 1992, it is not compulsory that his father needs to be citizen at the time of his birth. Either of the parents needs to be citizen of India. Then by means of birth, that person can be citizen of India. This is what is governing now, present. Fine. Person born outside India. Is it inside India? No. We are speaking about by descent, by blood relation. Okay. So it is a person born outside India after 3rd December 2004. Then the condition is that either of your parent needs to be citizen of India, and you will have to register within 1 year at the embassy. So now suppose you have been on a visit to United States of America, and if your child wanted to be the citizen of India, okay, if your child wanted to be the citizen of India, the condition is that either you or your partner needs to be citizen of India, and you will have to register within 1 year the name of the child at Indian Embassy, so that you will be, or your child will be recognized as citizen of India. So if you have plans to move outside India, keep this into consideration. Okay, if you have plans to move outside India, and if you want your child to be citizen of India, do not get confused. This is the condition. If your child wanted to be citizen of India, you should be citizen of India at least. If your partner is not citizen of India, that's okay. You should be citizen of India, and you should be remembering to register within the Indian Embassy within 1 year of the birth of the child. Fine. If you have forgot to register, if you have forgot to register the birth of your child in the Indian Embassy, no problem. Submit a special application that can extend the time period which is given. It is flexible now. Okay, flexible now. See, in one or the other way, you just try to imagine this situation. Why a person wanted to be citizen of India? You can understand that if a person wanted to be a citizen of US, then that person would be having, or that person would be looking for some benefit. But in India, a hugely populated country like India, if a person wanted to be citizen of India, means that is this emotional connection, isn't it? That is the reason why this flexibility is provided. Even if your child name is not registered in the embassy within 1 year, no problem, submit a special application. We can see whether it can be extendable or not. Fine. So that is how you can, in fact, be a citizen of India by descent. Fine, but there is a problem. You just imagine this condition. Suppose a child is born in US. Okay, so this is USA, not India. Fine, do not get confused. Fine, so this is USA. Child is born. Okay, US follows the principle of jus soli, which means a child who is born in the soil of US, regardless the citizenship of its parent, that child will be citizen of US. Okay, that child will be citizen of US. Suppose you imagine this condition that this child was having an Indian citizen father. So the father is Indian citizen. The birth has took place in US, born outside India after 3rd December 2004. Either of the parents citizen of India, and this father has soon ran to the Indian embassy and registered. How can India reject the citizenship of this child? This child is below 18 years of age. He is a minor. And how can India say that this is the decision of the child? So what you need to understand is that this is the only exception provided in the Citizenship Act, which means if this kind of situation happens, that means the child is by birth citizen of US, by descent citizen of India. If such a kind of situation happens, until the age of 18 years, this child will be holding double citizenship. Once the child has attained 18 years, within 6 months, decide whether you wanted to continue as the citizen of India or US. US does not have any problem, but we have problem. If you wanted to be citizen of India, renounce the citizenship of US. Otherwise, once the 6 months is getting over, your Indian citizenship will be automatically taken away. Getting this? So this is the condition. So in fact, there is a wonderful story regarding this. The story was, there was in fact a lady, I think who you would have heard about the story. This is not my version, in fact. So there was a pregnant lady. She was almost 9 months pregnant, and she took a flight from Hong Kong to US. And we know that it is legally not fair that this particular lady can board a flight in 9 months. She, through some fraud certificates and all, has in some or the other way boarded the flight. The flight took off. Soon she entered the labor. You would have heard the story, isn't it? Soon she entered the labor. Was very paining. And the passengers, the co-passengers asked her, "Madam, should we have or should we seek some medical help to enter into the delivery process?" Now this lady said, "No. Please go and check whether we have reached the US airspace. Please go and check whether we have reached the US airspace." Why? Why? Because if the child is born in US airspace, that child will get all the benefits of the citizenship of US. So finally, she has rejected the help. And the passenger said that after a few hours, the passenger said, "Madam, we have already reached the US airspace. Now, should we seek a medical advice?" "Yes, now please do." And she has successfully entered into labor and delivered, and the rest of the things are not necessary, and that child was recognized as the citizen of US by birth. And you would have heard so many people out from India, they wanted their child to be a citizen of predominantly European countries, isn't it? So they are ready to sacrifice anything. Many people's child wanted to be the citizen of US, so they go and do the delivery there, so that the child will get all the benefit of the citizen of US. Yeah, so that's it. Now the third condition is by registration. By registration. Sir, if you are not born in India and your parents were also not born in India, then is there a possibility for you becoming the citizen of India? That is the question. You are not born in India. You are not born to parents outside India who are Indian citizens. Now, is there a possibility to become citizen of India? Yes, that is the third alternative, by registration. Fine, by registration. So there are a number of categories. In fact, Madam Sonia Gandhi has got Indian citizenship by means of registration. She was not born in India. She was not born to Indian parents outside India. Then what was her relationship with India? It was Rajiv Gandhi. So if you are not born in India, your parents, or you are not born to Indian parents outside India, then there is a chance that you can become citizen of India by marrying a citizen of India. Fine. So you can make your husband or wife citizen of India after making that person residing in India for 7 years. Okay, if you wanted, say for example, if you wanted to marry a person from Mongolia, okay, if you wanted to marry a person from Mongolia and you wanted to make that person citizen of India, what you need to do is that you should ask that person, please stay in India for 7 years, and then submit the application. Okay, then submit the application, and the government of India will consider you recognizing the citizen of India. Fine. Now, this condition is even applicable for the person of Indian origin. What do you mean by person of Indian origin? Person of Indian origin. It is just that your ancestors have got a relationship with India. Kamala Harris, the Vice President of US, is a person of Indian origin. Why? Because her ancestors have got a trace from Tamil Nadu. So the definition as per the government's record is foreign national. So Kamala Harris is citizen of US. Foreign national whose parents, grandparents, or great grandparents has been citizen of undivided India. So those will be recognized as persons of Indian origin. So they are not citizens of India. They will be in fact a citizen of a foreign country, but their parents or grandparents or great grandparents may be citizen of India, which is undivided. So this is the definition of person of Indian origin. So in fact, Kamala Harris will come under the category of this. So if Kamala Harris wanted to be the citizen of India, if Kamala Harris wanted to be the citizen of India, how can she get it? How can she get it? Stay in India for 7 years and get the application or register the application. The government of India will consider recognizing the citizenship. Okay, fine. Yes. So this is what is regarding registration. Now, the fourth condition is by naturalization. By naturalization. Fine, by naturalization. In fact, who is this? Indira Gandhi? Mother Teresa. Fine. So Mother Teresa is one person who has got recognized as the citizen of India by means of naturalization. Why? Why was she not able to get citizenship by other alternative methods? Because he or she was not born in India. Was she born in India? No. She was not born to Indian parents outside India. She was not even married to a person who was citizen of India. She was not even person of Indian origin. Now, what is the next criteria? That is by naturalization. So, if by birth is not possible, by descent is not possible, by registration is not possible, don't worry, you have another criteria. So, can we recognize or can we give that flexibility for all those kind of individuals to be citizens of India? So that there can be so much, say, refugees, those kind of individuals who will come and seek for the citizenship of India. So the conditions will be very strict. And what are the conditions? See, you should compulsorily give up your previous citizenship. The first test is starting from here. If you need to be citizen of India by naturalization, compulsorily give up your previous citizenship. Okay, this is condition number one. Your intention should be very clear. Why do you want to be the citizen of India? That needs to be very clear. Even if somebody might say that I need to serve the people, the poor people of India. I need to serve India. I am very much affiliated to the cultural practices in India, the freedom struggle of India. So I wanted to die as an Indian. So the reason might be, or the reason should be very much justifiable. The third condition is that, sir, if you are so much in love with India, learn at least one language mentioned in the 8th schedule. So the condition is not that easy, isn't it? So one person say that, okay, fine, I'll give the previous citizenship. I will make my reasons very clear. Sir, if your reasons are very clear, then just invest your valuable time to learn one language in the 8th schedule. Because those are recognized languages of India. It is not for free. You just invest your time because you love India that much, isn't it? So please invest time if you wanted to be the citizen of India. And the next condition is that out of the last 14 years, that means suppose if today you are submitting the application, the government will see the previous 14 years from today back. And out of that 14 years, 12 years, this person should stay in India compulsorily. In other words, it is not an easy task at all. Are you understanding this? If you need to be a citizen of India by means of naturalization, 12 years you should have stayed in India. Out of the last 14 years, it is not out of the 90 years you have already lived. Are you getting this? Out of the last 14 years, suppose you are submitting the application today, the government is going to consider the last 14 years. That is from today, last 14 years. In other words, if you wanted to be citizen of India by naturalization, you will get only it after 12 years. After 12 years. That means out of 14 years, how many years you will have? You should have stayed in India. 12 years. So by naturalization, if you need to get citizenship of India, you should wait for 12 years minimum. It is not that easy. And that 12 years also is not flexible. See, that 12 years is also not flexible. That is, last 1 year should be continuous stay. In other words, when 14 years is considered before application, Okay, suppose you today submitted the application, then what is considered is that the 14 years, the just before 14 years, out of which the last 1 year you should be totally in India. Fine. The last 1 year you should be totally in India. Now what is remaining? 13. Out of 13, 11 years. You should be in India. That means 11 into 365 days, you should have stayed in India. But it is not compulsory. In other words, you can just say, for example, for 2 or 3 days, if you wanted to go to Pakistan and come back, no problem. But the last 1 year needs to be compulsory and continuous stay in India. So the total stay is 12 years, out of which 11 years you can break. Okay, you can go for picnic, no problem. But the last 1 year is compulsory. And these two conditions should be met in the 14 years prior to the application. Is it clear? Okay, it needs to be very clear. You submit the application today. What is going to be checked is 14 years before your application. Out of 14 years, you should definitely stay in India for 12 years. How should be this 12 years met? There's a condition that the last 1 year, it should be continuous. Fine. So 1 year is continuous, which means, remember, remaining is 13 years. Out of 13 years, please stay in India. 11 years, not continuous, no problem. Fine. So it is not that easy to get the citizenship by naturalization. It is by you're going through the trouble, the struggles, and finally you will be recognized as a citizen of India. In fact, Mother Teresa was staying in India for these much years to get recognized as the citizen of India. So this depends on your dedication to the country. If you have that much dedication, the level of dedication is that much. If you have that dedication to the country, only then you would be recognized by means of naturalization. Because you do not have otherwise any type of relation with this country. So you should show the love towards the country. You should make the government of India believe that you have got some reasonable intention to be part of India. Fine. So you would have heard about Adnan Sami, the celebrity artist. So that person was also recognized as the citizen of India. Even his father was the Pakistani Air Force pilot. But that person, Adnan Sami, has got recognized as the citizen of India. Why? Because his reasonable intention, his well-versed 8th schedule language, the criteria that is regarding the accommodation or stay in India was also met, which means he was ready to sacrifice for India, for Indian citizenship. Now we can't turn down the request, isn't it? Because such kind of people are actually the credit of the country. How can we turn down such request? Because 12 or 14 years means, you just imagine 14 years of your life means it is almost 1/4 or even 1/5 of your life. You are investing to get the citizenship of India. Such person should be definitely respected. That is the reason why Adnan Sami was given citizenship of India, even though his parent was Pakistani Air Force pilot who had participated in Indo-Pakistan war. Fine. So that is the condition. By naturalization, a person can be the citizen of India. And there is the fifth way, that is by incorporation of territory. By incorporation of territory. What does this mean by incorporation of territory? Yes. It means, suppose India is acquiring Pakistan. Okay, India is acquiring Pakistan. The individuals in Pakistan, they can be provided with the citizenship of India by a government order, which means that need not be a law, it can be an executive action. In other words, Prime Minister Modi as well as its Council of Ministers can decide whether we need to recognize the individuals in Pakistan as the citizens of India. He will not have to wait for the approval of the parliament. In other words, in real example, I can say you that Pondicherry was initially not part of India, isn't it? Pondicherry was in the custody of France. Now, in fact, when India or Pondicherry was made part of the Union of India, the people belonging to Pondicherry, they were in fact made the citizen of India by the Citizenship Order of 1962. So if you see the terms like order, notifications, or you may say even regulations, rules, these are in fact the actions of executive. Okay, these are in fact the actions of executive. But if you see the term law, act, these are in fact the actions of the legislature. In other words, this can be done by the parliament or the state legislature. This can be done by the executive. So what has happened here is that the Citizenship Act of 1955, in fact, has framed the provisions. And out of this, one provision says that if you need, in fact, to make certain individuals citizen of India, the government of India, you can release an order. Fine, you can just release an order and you can make those section of individuals as the citizens of India. Fine. So that is how the government of India, under the Citizenship Act of 1955, has issued this order. The name of the order is Citizenship Pondicherry Order 1962, by which the individuals of Pondicherry has got incorporated as the citizens of India. Now, see, suppose if you acquire Pakistan, there is no compulsory provision that all the individuals should be included in this order. You can just exempt, say for example, if you does not want, Mr. Modi does not want Imran Khan to be the citizen of India, Mr. Modi can exempt Imran Khan from that list. It is not compulsory that the entire section of individuals needs to be part of that order. Okay, so these are in fact the 5 ways in which a person can be or person can acquire the citizenship of India. Number 1, by birth. Number 2, by descent. Number 3, by registration. Number 4, by naturalization. Number 5, by incorporation. Clear? Fine. So just go through these 5 provisions. We'll be just finishing it in 15 minutes. So we are just having how can you lose the citizenship also, and after that we will end today's session. Okay, is it clear? Fine. Yeah. So how can a person lose the citizenship of India? Number 1, by renunciation. Okay, by renunciation. What do you mean by renunciation? It is giving away the citizenship. Okay, renunciation means giving away the citizenship. So this is just a voluntary action, that is any citizen of India of full age and capacity has got the power or the authority to renounce the citizenship. Full age and capacity means above 18 years of age. Okay, any person of India or any citizen of India of full age and capacity can renounce the citizenship of India. So this is one way by which you can give away or you can lose the citizenship of India by renunciation. So this is totally voluntary action. If I feel that I does not want to be citizen of India, I can renounce the citizenship of India. Okay, fine. The second one is by termination. By termination. What do you mean by termination? This is not your action, this is government's action. The government is taking your citizenship away. Why? Because of as the result of your action. That means you are voluntarily acquiring the citizenship of another country. Okay, you are voluntarily acquiring the citizenship of another country. That is the reason why your citizenship will be terminated. Okay, why your citizenship will be terminated. Voluntary acquirement of citizenship of another country. So first one was by renunciation. Second one is by termination, which means voluntarily acquirement of citizenship of another country. Third one, by deprivation. And what do you mean by deprivation? Deprivation means it is on the basis of your action. The government is taking away the citizenship. Say, for example, if you are, say, disloyal to the constitution, you are making statements like that you does not respect the Constitution of India. You are making statements that prove derogatory to the dignity of the Constitution of India. In all those cases, your citizenship can be taken away by the government. The second one, if the government of India realizes that you have been made or recognized as the citizens of India by concealment of fact. Say, for example, by naturalization, you have the condition of 14 years, isn't it? So you have made some fraud certificates, fake certificates, and you have proved in front of the government of India that you have been staying in India for the 14 years, the past 14 years. Or you have been staying in India for the past 12 years. But exactly you were not even here for 1 year. So if the government of India later realizes that you were a fraud, you were concealing the fact, in that case your citizenship can be taken away. The third condition is unlawful association with enemy state. Say, for example, if India is in war with Pakistan officially and you have got some illicit relationship with the Pakistan government, the Pakistan government in fact uses you for in fact getting the secrets out from the government. In that case also, if that is proved, your citizenship can be taken away by the government. Why? Because you are unlawful. You are unlawful association with the enemy state. The fourth one is that you are out of this country continuously for 7 years. You are outside this country continuously for 7 years. And you are not frequently registering at your embassy regarding your citizenship. Okay? Say for example, you are on a world tour for more than 7 years and you are completely blown away by that enjoyment. You does not care about the citizenship being taken away by the government or not. And after 8 years, you come to India and the government will take away your citizenship. Why? Because you were not even informing. What is the reason why you have left India? It was more than 7 years. But there are certain exceptions for students. Okay, students, officials in government service. Say, for example, Indian foreign service officials. They might be, say, for example, more than 7 years, they might be in another country, isn't it? They might be employed in another country, but it is your government who have sent them, isn't it? So in that case, even if they are outside India for more than 7 years, it's not an issue. International organization service of which India is a member of. Okay, international organization service of which India is a member of. Say, for example, you are assigned a duty by the United Nations. So United Nations is an international organization and India is a member of United Nations. So you are even serving for the betterment of India even, isn't it? That organization is formed for the betterment of the global geopolitics. So that organization is in a way contributing for the betterment of the world, as in the other way is contributing for the betterment of the world, including India. So if you are assigned a task by that organization, that means if you are assigned international organization service in which India is member of, and you are outside India for more than 7 years, no issue, your citizenship will not be taken away. The last condition is that, of course, if you register at the Indian consulate annually, even if you are outside India for 7 years, you should register Indian consulate annually. Yeah, every year. Okay, every year. Fine. Annual registration. So register at the Indian consulate annually, then your citizenship will not be taken away. Fine. So these are in fact the reasons or the ways by which your citizenship can be taken away or lost. Okay, so number one is by renunciation, number two by termination, and third one by deprivation. Now, the last topic for today. So this was the latest, in fact, the latest amendment of the Citizenship Act of 1955. So that was in 2019. And it was tremendously controversial. A huge controversy it was. So that you might have heard about. What was the reason? The reason was that, in fact, 6 religious groups from 3 neighbor countries of India, even if they are illegal migrants, and they have reached India before 31st December 2014, they will be recognized as citizen of India. Why? To stop religious persecution of minority communities. So here you will not see Islam, isn't it? Out of the 6 communities, can you see Islam community? No. Out of the 3 countries, do you see a non-Islam country? No. In other words, there is an intention of making a perspective that in the Muslim, okay, in the Muslim country or Islam Republic, there is religious persecution on Hindus, Christian, Sikh, Jain, Buddhist, and Parsi. So that is the reason why we are considering Bangladesh, Afghanistan, and Pakistan, those 3 Muslim countries. And in those 3 Muslim countries, as there is persecution or attack on the religious minority, who is minority there? Hindu is minority, Christian is minority, Sikh is minority, Jain is minority, Buddhist is minority, Parsi is also minority there. Their majority is Islam, isn't it? In Pakistan, majority is Islam. In Bangladesh, majority is Islam. In Afghanistan, majority is Islam. As they are in majority, they can attack these communities. So these communities, even if they are staying in India on the fear that they will be attacked or persecuted by the majority in that country, Even if they are illegal migrants, come on, you will be recognized as the citizens of India if you have came to India before 31st 2014 December. Okay, before 31st December 2014. In other words, for this category of individuals, naturalization requires only how many years? No. For those people who have came to India before or on December 2014, those persons will have to stay in India only for 6 years to get recognized as the citizen of India. This amendment is in 2019 for 5 or 6 years, which means it is not 14 years requirement. So this is what is in fact the latest amendment providing for. And also there is no, I mean, contemporarily, or you may say that in this year's prelims, we does not have any reference to this amendment, but still this is the latest, in fact, change in the Citizenship Act of 1955. Okay, is it clear? Fine. So this is what you need to understand regarding the citizenship of India. Okay, these are the things which you need to understand regarding the citizenship of India. And always remember, the Constitution provides only limited provisions. It is mentioned under, or the Constitution provides only limited provision under Article number 5, 6, 7, 8, 9, 10 and 11, which gives the power to the Parliament of India. So the rest of the matters will be dealt by the Parliament of India. Even the laws of citizenship, the acquisition of citizenship, and all other matters relating to the citizenship will be dealt by the Parliament of India. So that is the status quo of the Citizenship Act.